Are you serious? They seriously built a garage blocking my driveway!
Because what I am about to tell you is a kind of story that sounds too satisfying to be real. But every single word of it is true. And by the time we get to the end, you are going to want to stand up and applaud. My neighbor built his garage on MY property. Not near my property. Not close to my property. Oh, and it. 18 inches of his concrete foundation sitting on land that legally, officially, and undeniably belonged to me. And when I walked over and told him about it, he laughed at me. So I spent the next 2 years making sure that $28,000 garage became the most expensive mistake he ever made in his life. This is that story, from the very beginning. The setup, spring of 2019. I bought my first house. 3 bedrooms. Quiet suburb outside Columbus, Ohio. Good street. Good neighbors. And one thing I love more than anything else about that property. The driveway. Now before you laugh, hear me out. I spent 6 years in apartments before this. 6 years of street parking. 6 years of circling blocks at midnight. 6 years of parking meters and permit stickers and the constant low-level anxiety of wondering if your car is still where you left it. And then one night, a Wednesday 11 p.m., I walked outside and my car was gone. Towed. Just like that. $420 to get it back from the impound lot. So when I saw this driveway, wide, clean, freshly sealed concrete, room for 2 cars, no meters, no tickets, no arguments, I felt something in my chest finally relax. This was mine. Remember that word. Mine. It becomes very important very soon. Enter. Gary. The house to my right had been vacant for 8 months when I moved in. Previous owner had passed away. Estate situation. Quiet, empty house sitting on the lot right beside me. Then in August 2019, a truck pulled up. The man who stepped out was around 50. Stocky, confident walk. He saw me checking my mail. Came straight over, hand already extended. Gary, he said. I shook it. Told him my name. In the next 4 minutes, Gary told me he bought the house below market value, had connections in construction, and, most importantly, was going to build a garage. A real garage. Poured concrete floor. Insulated walls. 2-car. The full package. I told him that was great. And I meant it. New garage improves the whole neighborhood. Good for everyone's property values. We shook hands again before he went back to unloading. That handshake felt like a promise. We're going to be good neighbors. We understand each other. We've got this. Remember that handshake, too. The build, permit filed in September. Contractor arrived in October with a 3-man crew. 3 weeks of construction noise, saws, nail guns, concrete mix on a Saturday morning. I watch from my kitchen window sometimes. Nothing unusual. Foundation poured. Framing up. Walls done. Nice charcoal carriage doors at the end. Looked sharp, honestly. Crew packed up Friday afternoon. Drove away. Weekend was quiet. Monday morning I walked outside for work. Coffee in hand. Keys in the other. Already thinking about my morning meetings. And something stopped me. Not a sound. Not a person. A feeling. Something about the left wall of Gary's garage and the way it sat next to my driveway. I set my coffee on the hood of my car. Walked to the left side of the driveway. Crouched down. Looked along the edge. And there it was. Gary's concrete foundation was not AT the property line. It was past it. On my side. I measured with my palm. 4 inches per palm width. Counted 4.5 times. Roughly 18 inches. 1.5 feet of his garage, sitting on my land. I stood up, walked to his door, knocked. He answered in his bathrobe, coffee in hand. Half asleep. I said calmly, Gary, I think we have a problem with where the garage ended up. He looked at it, sipped his coffee slowly, and said 7 words that started everything. Hey, I don't think it's a big deal. Went back inside, closed the door. I stood there for a moment, picked up my cold coffee, looked at that garage wall one last time, and thought very quietly, okay, Gary, let's find out. When we left off, Gary had just told me that 18 inches of his garage sitting on my property was not a big deal. And I had decided, very calmly, very quietly, that I was going to prove him wrong. But here's the thing most people get wrong when a neighbor dispute starts heating up. They get emotional before they get documented. They go back and knock louder. They argue in the driveway. They post angry things on the neighborhood Facebook page. They say things that get screenshot. They make threats they cannot back up. And then when lawyers get involved, they have nothing, just their word against the neighbor's word. I was not going to make that mistake. Step 1. The surveyor. That same day I went to work, did my job, came home, made dinner, sat at my kitchen table with my laptop, and searched for licensed land surveyors in my county. Not because I was going to win on emotion, because I was going to win on facts. Found one with strong reviews. Called next morning. Explained the situation. She booked me for the following Thursday. Cost $850. Remember that number. It becomes very funny later. Surveyor arrived Thursday morning. Older man, mid-60s, beat-up pickup truck. Set up his equipment with the calm efficiency of someone who had done this exact thing 10,000 times before. He found the original property marker stakes, small metal pins driven into the ground during the original subdivision of the neighborhood. He ran his measurements, took photographs, made careful notes. When he finished, he walked over to me and said in the flattest voice I have ever heard, "Your neighbor's structure crosses the property line by 19 inches. 19 inches, not roughly 18. Not approximately. 19. Measured with professional instruments. Confirmed against original county markers. Documented with photos and precise coordinates." I watched him stamp his report. I wrote him a check and thanked him sincerely. Step 2. The attorney. That evening I called Margaret, real estate attorney, recommended by a co-worker who had used the firm for a boundary dispute 2 years earlier. I walked into her office the following week with a stamped survey, my own photographs, a copy of my deed, and printed county property records, all organized into a tab-divided folder. Margaret reviewed everything, asked a few precise questions. Then she put the survey down, folded her hands, and said, "This is a clear encroachment. You have a strong position." She explained 3 options. 1. Sue for encroachment, force court-ordered removal of the structure. 2. Negotiate a paid easement where Gary pays me permanently for the right to keep his garage where it sits. 3. File a complaint with the city building department, threatening Gary's certificate of occupancy. But before any of that, Margaret told me something I wrote down word for word. Before you choose your weapon, give him one formal written opportunity to fix it. Certified mail. Make sure he signs for it. Reason. It establishes on the legal record that you acted in good faith before escalating. Judge's notice. It matters enormously. I told her to write the letter. The letter, 3 pages. Polite like a scalpel is polite. Precise. Clean. No wasted words. It laid out the survey findings. The 19-inch measurement. The Ohio state statute on property boundary violations. A formal demand that Gary either remove the encroachment within 60 days or negotiate a compensated easement. It made clear that failure to respond meant legal action, and a formal building department complaint. Sent certified mail on a Thursday. Paid for the return receipt. Gary signed for it Monday at 10:14 a.m. I have the receipt. Still have it today. Filed under G. For Gary. He called me that same afternoon. And here's where Gary made his real mistake. Not building over the line. Maybe that was an honest error. No, this mistake was different. He laughed. Not nervously. Not apologetically. The laugh of someone who thinks they are watching a bluff. He said, direct quote, written down within 5 minutes of hanging up. "Man, you really went and got a lawyer over this. Over like a foot of concrete." I said calmly, "Gary, the letter explains your options. I'd encourage you to read it carefully." He said, "I'm not tearing down my garage. You want to make something out of this? Go ahead." He hung up. I texted Margaret immediately. 4 words. He declined. "What's next?" She replied within the hour. "We file with the building department tomorrow." The inspection. Here is what most homeowners do not know. A certificate of occupancy is the legal document that allows a structure to actually be used. No CO. The building exists but cannot legally function as anything. Gary's garage had a permit filed. But the final inspection had not happened yet. The CO had not been issued. The garage was sitting in that window between built and legally approved. We filed a complaint within 48 hours. Included the survey, the photographs, the measurements, and proof the as-built structure did not match the original permitted plans. The city sent an inspector within 3 weeks. He measured. He compared. The difference was not subtle. 2 days later, a certified notice went up on Gary's front door. Gary's garage had failed its final inspection. Certificate of occupancy denied. $28,000 for a garage he could not legally use. I was on my porch watering a plant when he read that notice. He looked over at me. I gave him a small wave. He went inside without a word. Gary's garage was officially non-compliant. Certificate of occupancy denied. $28,000 sitting there producing absolutely zero value. And you would think, at this point, the smart move was obvious. Hire a contractor, fix the encroachment, get the inspection passed, move on. But Gary did not do the smart thing. Gary did the Gary thing. He hired a lawyer. The legal fight begins. I understand why he fought. Nobody wants to admit a $28,000 mistake and then spend more money fixing it. The ego does not want to accept that reality. So Gary's lawyer sent a letter to Margaret arguing the survey was inaccurate. Wrong reference points. New survey would show different results. I want you to think about that strategy. Gary's defense against a professionally stamped, legally certified survey was, maybe the surveyor got it wrong. Margaret responded with the original property deed, county GIS records, the surveyor's professional license number, and a second independent survey I had already commissioned the moment Gary's lawyer challenged the first. Different surveyor, different firm. No knowledge of the first survey's findings. Second survey confirmed the first survey to within half an inch. Gary's lawyer went quiet for 3 weeks. New strategy, same result. Then a new letter arrived. This one stopped challenging the survey. Instead it argued, even if the encroachment is real, the correct remedy is not removal but a forced easement. Gary pays me once. Keeps his garage where it is. Case closed. Now, I have to be honest here. Margaret told me this was a legitimate legal argument. Courts sometimes DO order easements when demolition costs are disproportionate to the harm caused. There was a real scenario where a judge could say, Gary pays you, garage stays, move on. I asked Margaret directly, how do I stop that from happening? She said 2 words, document the harm. Documenting everything. For the next 4 months, I kept a detailed log. Every time I had to angle my car awkwardly because the driveway was narrowed, written down with date and time. Every time I scraped close to the garage wall pulling in, photographed. Every time a guest had trouble parking because of the reduced space, noted. Dates, times, weather conditions, all of it. And then I did something that surprised even Margaret. I got contractor quotes. 3 separate licensed contractors gave me written estimates on official letterhead for widening my driveway on the other side to compensate for the reduced access. Quotes came in between $4,200 and $6,800. Suddenly the harm I suffered had real dollar amounts attached to it, from real professionals. On paper, our Gary's winter. Meanwhile, picture this clearly. Gary's $28,000 garage sat completely unusable through an entire Ohio winter. Every single morning, he shoveled his car out of the open driveway, scraped ice off his windshield in 12-degree weather, walked past those beautiful charcoal carriage doors every day, knowing he could not legally park behind them. I watched this sometimes from my kitchen window with my morning coffee. I did not feel guilty. I had given him every chance to fix it. The first settlement offer. Around month 5, Gary's lawyer made an offer. Gary would pay me $3,500. I would sign a permanent easement. Case closed. I sat on it for a full week. Then I sent my counter. $11,500, covering the contractor quote plus compensation for months of documented inconvenience. Gary removes the encroachment at his own expense, gets a certificate of occupancy, and we never speak of this again. Gary rejected the counter. His lawyer called it unreasonable. I said, through Margaret, I'm prepared to take this to court. And then something interesting happened. Gary's lawyer asked for a 60-day pause in proceedings. They needed time to review all options. Margaret told me what that meant. They were finally getting a contractor to estimate the actual cost of demolishing and rebuilding the encroaching section. 6 months too late, with their legal fees already mounting. And the math, I already knew, was going to be absolutely brutal for Gary. The power of time. Here is what Gary never understood. He thought delay would wear me down, that lawyer letters and long silences would make me want to settle cheap just to end the stress. He did not account for what time was costing him. Every month, his legal fees grew. Every month, his garage sat worthless. Every month, a $28,000 structure produced nothing but frustration. I was inconvenienced. He was financially bleeding. The 60-day pause expired. They asked for 30 more days. I approved it without hesitation, because at this point time was the most powerful weapon I had, and I was in absolutely no hurry to put it down. I need to explain something that most homeowners never know until they desperately need to know it. When a structure is officially flagged as non-compliant and the owner fails to fix it within the remediation window, the municipality does not just wait forever. They act. The notice of non-compliance. The Columbus Building Department had given Gary a standard remediation window of 6 months. 6 months to either bring the garage into compliance or obtain an official variance. A variance means formally petitioning the city to allow the non-compliant structure to remain. But here's the critical part. A variance for a property encroachment requires a written consent to the affected neighboring property owner. That was me, and I was never going to give consent. So Gary had two and only two paths forward. Fix the structure, or get my signature. He did neither. When the remediation window closed, the city issued a notice of noncompliance. And here is why this is so much more powerful than it sounds. A notice of noncompliance is not filed against Gary as a person. It is recorded against the property itself, against the legal title of his home. It becomes part of the permanent public record, visible to every future buyer, every mortgage lender, every title insurance company, every real estate attorney who runs a search on that address. And what that means in practical terms. You cannot sell a home with an unresolved title issue. You cannot refinance your mortgage. You cannot take out a home equity loan. You cannot do any of the major financial moves that homeowners depend on for flexibility and security until the title is completely clean. Gary's title was not clean. Gary was completely and utterly stuck. The knock on my door. I found out about the notice of noncompliance through a public records request Margaret had suggested early in the process. When the notice was officially recorded, I received a copy. I want to be honest about what I felt. Not joy, not cruelty, vindicated, because every single step of this disaster had been Gary's own choice. He chose not to check the property line before building. He chose to dismiss my first conversation. He chose to laugh at the certified letter. He chose to fight the survey instead of simply correcting a mistake. Nobody did this to Gary. Gary did this to Gary. About 20 months after that Monday morning when I first crouched down and measured with my palm, Gary knocked on my front door. Evening in early spring. I answered. He was standing there without the bathrobe this time. Regular clothes. Quiet energy. He looked like a man who had spent too many recent nights staring at numbers that did not add up in any direction. The confidence was completely gone. The shrug was gone. The "it's not a big deal" was nowhere to be found. He asked if we could talk. I said yes. Come in. The kitchen table. We sat at my kitchen table. He had a folder with him. He had finally gotten contractor estimates, real ones, for tearing down the encroaching section, adjusting the foundation, and rebuilding the wall on the correct side of the property line. The quotes, between $17,000 and $21,000, on top of the $28,000 he had already spent building the garage, on top of $12,000 in legal fees. He was looking at a total loss of somewhere between $50,000 and $60,000 for a garage he still could not park in. He looked at me across the table and asked, directly, without any of the old confidence, what it would take to make this go away. I appreciated the directness, so I was direct back. I said, the encroachment gets removed, or you compensate me fairly for permanent use of my land. My number, updated slightly to account for the additional months, was $14,000 for the easement. He flinched. He asked if we could do $9,000. I said no. A long silence. Then he asked, was $11,500 still on the table? I said yes. It had always been on the table. He closed his folder, looked at the table for what felt like a very long time. Then he said, "Okay." We shook hands across my kitchen table. The first handshake had been about optimism, new neighbors, fresh start, good intentions. This handshake was about something else. This was what consequences look like when they finally arrive. The resolution. Within 3 weeks, Margaret and Gary's attorney had the easement agreement drafted, signed, and submitted for recording. Gary wrote me a check for $11,500. The notice of noncompliance was cleared. The easement was officially recorded. The title was clean. The city issued the certificate of occupancy. Gary could finally, legally, park in his garage. He used it for about 4 months. Then he listed the house and moved out. I watched the moving truck from my kitchen window, the same window I had watched his garage go up from over 2 years before. He did not knock on my door before leaving. He did not wave. He loaded his life into the truck and drove away. And I felt nothing but peace. The money was in my account. The easement was in the public record. The driveway was mine, protected forever. Some lessons cost $28,000. Some cost $50,000. Gary's lesson cost him everything he put into that garage, $12,000 in legal fees, and $11,500 directly into my bank account. All because of 19 inches. All because of, it's not a big deal. You now know the full story. Gary built over my line. I documented everything. The city got involved. His title got frozen. He came to my kitchen table and wrote me a check. Satisfying? Absolutely. But I did not come back to tell you this story just for the satisfaction. I came back because there are 6 real lessons inside this experience that can protect you, whether you are dealing with a property dispute right now or just want to be ready if one ever starts. Let me break them down. Lesson 1. Document before you do anything else. Everything I achieved came from paper. A professionally stamped survey. A certified letter with a return receipt. Contractor quotes on official letterhead. A dated log with times and photographs. Without those documents, I am just another angry homeowner with no leverage. With those documents, I had an airtight, professionally supported, legally actionable case that nobody could argue with. The moment a dispute starts, even if you are hoping it resolves itself, you begin documenting. Today, not tomorrow, not after the next conversation. Today, photographs, dates, times, written notes, saved text messages, everything. Your future self will thank you in ways you cannot currently imagine. Lesson 2. Never get emotional before you get legal. I know how badly you want to go back over there and explain loudly exactly how wrong they are. Do not do it. The moment you go emotional, you hand them the narrative. You become the difficult neighbor. You give their lawyer something to work with. Gary would have loved it if I had come over yelling. It would have given him a story to hide behind for the entire dispute. Instead, I came over once, calmly, said my piece, and then let the legal process do every single thing after that. He never got to paint me as the aggressor, because I never gave him the material. Lesson 3. Know your local property laws. Most homeowners have never heard of a certificate of occupancy until they need one. They do not know what clouds a title. They do not know what a recorded easement means for a future sale. You do not need to become a real estate attorney, but you absolutely need to understand the basic legal framework of the thing you paid hundreds of thousands of dollars to own. What a survey is, what a CO means, what a notice of noncompliance does to a title, what an easement is and how it gets recorded. These are not complicated concepts. They are the rules of property ownership, and they work for you when you know them. Lesson 4. Time is your weapon when you are right. Gary thought delay would break me down. He thought 6 months of legal back and forth would make me desperate to settle cheap. He completely miscalculated, because every month that passed, his legal fees grew. His unusable garage depreciated in frustration value. The financial pressure of a $50,000 problem with no resolution pressed harder on his entire life. I was inconvenienced. He was bleeding. When you are in the right, let time work. The person who made the mistake carries the weight of it every single day. You just have to be patient enough to let that weight do its job. Lesson 5. Always give real off-ramps and mean them. This one gets lost in the satisfying ending, and I do not want you to miss it. I genuinely gave Gary every opportunity to make this right. The first conversation was real. The certified letter was a real offer with real options. The settlement negotiation through lawyers was genuine good faith. I was not stringing him along. I was giving him actual exits every step of the way. The best outcome, for everyone including me, would have been Gary correcting the garage in month 1. A few $1,000s in contractor work. Clean, simple, done. He refused every single exit. That is what turned a small problem into a $50,000 catastrophe. Give people real chances. Mean it every time. And document every offer you make. Lesson 6. The story you tell yourself is not the truth. Gary told himself a story. In his story, a couple of inches was not a big deal. The survey was probably wrong. The letter was a bluff. The city notice was something he could wait out. Every decision he made came from that story instead of from reality. We all do this. It is deeply human. Our brains build narratives that protect our choices and our ego. Gary's narrative cost him somewhere between $50,000 and $60,000 before it finally collapsed. The most powerful thing you can do in any conflict is strip away the story, yours and theirs, and look at the raw facts. Who owns what the documents say, what the law says, what the numbers actually are. That clarity kept me calm throughout 2 full years of this dispute. Not anger, not ego, just facts. And in the end, facts won. The final chapter. Gary moved out in the spring of 2022. I watched a moving truck from my kitchen window, the same window I had watched his garage go up from 3 years earlier. He did not knock on my door. He did not wave from the driveway. He put his life into a truck and drove away without looking back once. And I did not need him to say anything. The $11,500 was already in my account. The easement was already permanently recorded in the county public records. My driveway was legally protected forever. Some endings do not need words. They just need paperwork. The new owners moved in about 2 months later. Young couple, mid-30s, 1 child, clearly another on the way. They knocked on my door within the first week, friendly, warm, excited about the neighborhood. They asked if there was anything they should know about the street. I told them, quiet neighborhood, great people. The Thai restaurant on the corner is excellent, and there is a recorded easement attached to your property that your title company should have explained at closing. They looked slightly confused. I told them not to worry. Old paperwork, fully resolved, no outstanding issues, which was completely true. The easement was settled public record. It will show up in every future title search on that address for as long as the property exists. Gary's decision to build 19 inches over the line will follow that address in county records essentially forever. That is not revenge. That is just how property law works. The record is a record. The driveway today. I had the driveway fully resurfaced in the summer of 2022. Fresh concrete, clean edges, professional sealant finish. It looks better today than the day I first moved in. I stood in that driveway the morning after the crew finished, coffee in hand, and I thought about that $850 survey and everything it returned. Not just the $11,500, not just the money, the principle, what this was really about. Because here's what I need you to understand before you click away. This was never about revenge. This was about one thing and one thing only. Your property is yours. The lines defining what you own are not suggestions. They are not approximations. They are not social courtesies between neighbors. They are legal facts, recorded in county offices, protected by statutes, enforceable by courts and building departments and city inspectors with clipboards and stamp pads. And when someone crosses those lines, whether by accident or by arrogance, you have every right to stand up and say, "No, this is mine," and you will respect that. For anyone going through this right now, I want to say something directly to you. If you are watching this because you are in the middle of something like this, a neighbor who built too close, a fence in the wrong place, a structure on your land, a dispute that feels overwhelming and expensive and endless, I want you to hear this clearly. You can win, not with anger, not with social media posts, not with screaming matches in the driveway. You win by being more organized than they are, by knowing the rules better than they do, by having professional documentation when they have nothing but attitude and excuses, by staying calm when they expect you to explode, by being patient when delay feels like defeat. The surveyor exists for you. The building department exists for you. The certified mail system exists for you. The recorded easement process exists for you. All of these tools were built over centuries of exactly these kinds of disputes. Because neighbors have been arguing about property lines since the first day two people decided to live next to each other. And civilized societies eventually decided there needed to be reliable, documented, enforceable ways to resolve those arguments. Use the tools. Trust the process. Document everything from day one. And if your neighbor ever builds a garage over your property line, looks you in the eye, and tells you it is not a big deal, make it the biggest deal they've ever seen. Because you pay for every single inch of that property. And nobody gets to decide the rules do not apply to them just because they are betting you will not push back. Push back. Stay organized. Stay calm. And win. That is what I did. And I would do it exactly the same way every single time. Outro. Thank you for watching all 6 parts of this story. If it connected with you, if you have been through something like this, or you are in the middle of something right now, please subscribe. Hit the bell. I share real stories like this about property rights, neighbor disputes, and the legal tools most homeowners never know they have until they need them. Leave a comment below right now. Have you ever had a neighbor dispute? What happened? How did it end? I read every single comment, and I will see you in the next one.